let me call the meeting to order. Let everyone please give us your attention. We'll try and keep the door closed where everybody can hear what's going on if we can in here. And we're going to have a fairly long agenda. We've got a quorum, I believe, present. Yep. And the lovely Miss Jill Travis has joined us. Always happy to see you, Miss Travis. Let's roll a while, right. We can try and, if you have any cell phones, be sure they're put on vibration for the duration of the time you're in the meeting room. The first thing we're going to do, we have a bill that was filed by Chairman Powell, House Bill 397. I'll have to read your district number. And I think you have with you the Attorney General, Sam Olens. Glad to have you here, sir. And why don't you go ahead and present what you're going to have done with this.
All right. Thank you, Mr. Chairman. This is House Bill 397. There is a committee substitute that I think has been placed in everybody's folder that was filed today with the committee. And generally, this is a comprehensive revision of the Open Records, Open Meetings Act. I've been working with the Attorney General since the session started on this. He has engaged all of the stakeholders and has been dealing with them almost throughout the session to get to the point where we are. But at the same time, probably 80 to 90% of this bill is a rewrite of existing law just to make it clearer so that it doesn't take a Philadelphia lawyer in order to understand the open records, open meetings, so that it is readable and understandable by the layperson. The rest of it is dealing with items that have either developed in the previous years or abuses that have developed in previous years that need to be addressed. And so the Attorney General and his office have worked very hard in trying to address all of these issues. However, because it is such an important piece of legislation, we also understand that there are a lot of people that still have comments on that. And what we have done is we've introduced this. We would like to encourage people to contact either the Attorney General's office or myself with their comments, with their suggestions, and even with their criticisms, so that what we would like to do, and I think the chairman is interested in doing, is to, when we're in Atlanta this summer for reapportionment, that we also schedule some committee meetings when we aren't under the rush of additional legislation, and hear from the stakeholders and address this so that we will be prepared at the beginning of the next session to go forward with a bill that everybody can be comfortable with. And yeah, but if I can do it all in one sentence, we can get through. And
how far you can go with one breath.
So anyway, what we'd like to do is just make the committee aware of this and what our plans are, and I would like the Attorney General to address these issues as well, and then we would, rather than having a hearing today, just leave it in the breast of the committee with the understanding that we want to deal with this in a comprehensive way later.
Thank you. Those brief comments.
Thank you, Chairman Willard. I want to thank you for the opportunity to be working on this bill with you and to be here with the committee. I want to especially thank Chairman Powell. This is a matter that requires significant clarification due to the numerous appellate decisions, numerous abuses that my office sees. Stephen Ritter in particular is here from my office, and he's done the lion's share of this work and has done a great job.
Great lawyer, by the way.
Excellent.
Ritter is. Won a case for us one time.
Excellent. Hopefully more than once.
One time I was with him anyway.
We have continued to work, as Chairman Powell has stated, with the various stakeholders from Georgia Press, ACCG, GMA, School Board Association, you name it, we've met with them. I would suggest to you that the vast majority of this bill meets with their approval and that they like the bill. There are clearly going to be sections that are going to be appropriate for committee hearings and for to hear insight from this committee before it would go to the full House. We're in total agreement with Chairman Powell on the ability to have hearings this summer so that maybe we would then, the beginning of next year, be able to have this passed and then go to the Senate. And we just want to thank you very much for the time today and especially for Chairman Powell's leadership in having this matter move forward.
Thank you so much, and that is pretty much what we're going to do is have this bill published on the website so that everyone has access to the substitute House Bill 397. Look at as a substitute is one we're considering. Well, maybe you can put it on your website. We'll put it on the Attorney General's website then as a bill that will be under review and consideration. And what we will do is, as mentioned, Ms. Powell, we will hold hearings probably during the time we're having reapportionment, as we do have some sit-around time available then. And we'll get a full hearing at that point. There won't be any further input today to the bill.
Thank you, Mr. Chairman.
Thank you both.
Thank you.
I know we have Ms. Cooper here who's needing to get to another hearing. Sharon Cooper, I thought I saw, there you are. Come around, please, ma'am, and have a seat if you would. This is on House Bill 229 in your folder.
Thank you, Mr. Chairman, members of the committee. This is the bill that is dealing with how DCH handles our Katie Beckett children and our medically fragile children that need our help. It is a bill to try to move the process along. There's been a lot of input. There was a reason it's coming in the final form so late, because many of the members wanted to make it stronger, but we've gone back to the original bill except for changing 30 days till 10, thinking that this was a good first step and to move it on. I know the department will have comments to make, and that they have agreed to do certain things, but it seems like we've been asking for those things for many years, and there hasn't been any movement until this bill began to make progress, and the committee comments were such that the department realized how bad the situation had become and how concerned we were. Be glad to answer any
Thank
questions.
you. For everyone's benefit, we are working off LC 294680S. And do you have anyone else you want to
Yes, sir.
speak for the bill?
Do you want the sign-up sheet?
That's good. Thank you. I didn't have it over here. We will have you. We have on House Bill 229, Catherine Ivey and Lynette Rhodes, Department of Community Health. If you would like to please come forward, and both of you, or both of you, yes, good. If you both take the seats, and we will appreciate your comments on the bill.
Yes, Mr. Chairman and members of the committee, we have some
I want
handouts.
you to introduce yourself and how you are
I will.
employed with. You're with DCH, right?
Yes, sir. My name is Catherine Ivey, and I am the Director of Special Populations for DCH and manage the long-term care programs.
Thank you.
You're welcome. I have some handouts that may be helpful.
All right, we got committee aid somewhere, but don't see him around.
And the handouts that are being passed out have been distributed before, and Representative Cooper noted what they outlined, which is some changes that we've made in the general process, particularly to the Katie Beckett eligibility. The first one outlines the timeline of events, and there was a lot of concern about how long it takes to determine Katie Beckett eligibility for medically fragile children. So we put together an outline of the sequence of events, and it is true, it does take a long time. Knowing this, we went back to the drawing board and streamlined much of the process, which is the subject of the handout you have that has some graphs on the front. We've been able to eliminate some of the required documents, which was a lot of the concern, is that parents were asked to provide a lot of documentation of a medical nature to provide the basis of a medical determination for eligibility. And we've been able to significantly streamline that process. through deciding what we actually did need and didn't need. And I'll just leave these for your review. It outlines what we've been able to streamline.
Go ahead. Excuse me. Let's have your name and your relationship to DCH.
Yes, my name is Lynette Rhodes, and I am the current Director of Legal Services within the Department of Community Health. I appeared before the subcommittee, I think maybe a week or two ago, and presented some information. I brought additional copies because I don't recall exactly who was here last time and who's here today. But I wanted to explain to you what we do in legal services and how the proposed bill would affect us. We handle appeals for all waiver programs for both Medicaid members and Medicaid providers across the state of Georgia. So we're within our section, we receive appeals from any place, from any member or any provider in the state of Georgia. We're not just limited to Katie Beckett appeals. We handle appeals for various programs, the Georgia Pediatric Program, Independent Care Waiver Program, Pharmacy Lock-ins, Emergency Medical Assistance, several others. In addition to the member programs, again, we also handle provider appeals. So if you are a Medicaid provider, such as a physician or a home health agency, and you have an appeal regarding reimbursement issues or claims issues, we also handle those appeals as well. So I wanted to make clear that we are not just limited to Katie Beckett matters. Our current staffing within legal services consists of 4 full-time staff attorneys, 1 part-time staff attorney. We have 3 contract attorneys, a secretary, and a paralegal. And just to tell you, to give you an idea of the number of appeals that we received in 2009, and this is for provider and member appeals, we had 587. For 2010, we had 847. For 2011, as of March 1st, we've had 113. The time that we spend on administrative appeals could vary anywhere from 6 hours to 160 hours. It just depends on the facts of the case. And again, that's for a member appeal or for a provider appeal. So it varies. I presented last time, and I have copies today. Okay. Do we need more copies of those? Or? Okay. In preparing our appeals, I wanted to explain to you all what would normally be taken into consideration. Of course, there's a review of the file. Keep in mind, we travel to all of the hearings that we hold for members. So we're talking about appeals and hearings in Savannah, Georgia, Valdosta, Augusta, Athens, anywhere within the state of Georgia. Whatever county that member resides in, we travel to that location to hold the administrative hearings. So those are not held here in, within our office or limited to Fulton County. We do have to prepare our witnesses for the hearing. Our witnesses are DCH staff. They also travel with us to those hearings. So we do take into account that we have a limited number of witnesses because, of course, our witnesses are agency staff. With regard to the provision that the department no longer have the ability to render a final decision, I presented to you 42 CFR 431.10. That is the provision that tells you that the Department of Community Health is the single state agency that administers the Georgia Medicaid program. I've also presented to you 42 CFR 205B, which outlines the provision of hearings for Medicaid appeals. If you look at section 42 CFR 205B, that provision tells you that...
I don't think I've got that.
You don't have that one? Oh, sorry. Okay. And I have a few extras if you need some more. Okay.
Let me ask you, Ms. Rose.
Yes, sir.
Maybe cutting to the chase a little bit. Will you be contending that if this were to pass, we may be doing something contrary to what you have as far as federal regulation?
Yes, sir.
Okay. If you would, why don't you just point out what that provision
Okay.
is and where the bill may have some language that speaks
Okay.
in conflict to that.
Got you. On the bill, if If I may direct your attention to line 34 and 35,
All right.
where it states the decision of the administrative law judge shall be the final administrative decision of the commissioner. That provision would in fact be in violation of federal regulation. If you look at section 42 CFR 431.205, it outlines for you the hearing system, and it tells you that the state's hearing system must provide for, number one, a hearing before the agency, which would be DCH. Then it says, or, number two, an evidentiary hearing at the local level with a right of appeal to a state agency. Currently, all of our appeals are transmitted, well, I won't say all, the majority of our member appeals are transmitted to the Office of State Administrative Hearings. There, the administrative law judge will issue an initial decision or a recommendation. From that point, the next level of appeal is to the Department of Community Health, which is the agency. That is what this Code of Federal Regulation provision requires. The current bill would in essence be in violation of that provision because it would make the ALJ's decision the final decision of the agency, if that makes sense.
So your concern is being called a final decision of the agency, even if there's a reversal of the agency's decision.
Yes, but I mean
that's one point. My point is, if the administrative law judge, ALJ, says, agency, you made an incorrect decision, I'm going to rule differently, that is not your agency's decision, what you're concerned about.
Correct.
It may be an appealed decision, but it's not your department or your agency's decision.
Exactly.
Okay.
Right, whether we, win or lose.
Right. I guess I get to the point about it. If the language was to say that that decision would be a final decision, with that removing the issue about it being considered a agency decision.
Well, as long as there is a provision that it will still be appealed to the agency, and DCH will then issue its final determination. So I guess in essence the answer would be no, because the ALJ's decision would in fact not be final.
All right. So now there's nothing that really involves a ALJ in the process.
In the initial decision, yes, you would first appear before the ALJ, and then either party correct, and then either party could appeal to the agency, to DCH.
Okay, so DCH could, under that appeal, still be able to reverse what the ALJ may have ruled.
Exactly.
All right.
And again, that's for either party.
And that's where you say the evidentiary hearing at a local level, ALJ in this case, with a right to appeal to a state agency hearing.
Correct.
Does the federal law, you're saying, mandate that what the state agency says will be a final hearing and there is no appeal from it?
No. The way the process works is you would appeal to DCH, we would issue a final decision, and from there either party could appeal to the Superior Court. And then that's, and from there to the Court of Appeals, or, until the case is resolved.
Thank you. Okay. Does that cover your point on that?
Yes. Yes, sir.
All right. And
I just wanted to also point out again that we are the single state agency, and you already have that provision, I think, before you.
We do. Questions of members of the panel? I'm going to get you back up here, if you will. Ms. Stevenson?
Yes.
Go ahead.
Thank you, Mr. Chair. Thank you for your comments. I have a couple of questions for clarification. You're reading the CFR and stating that the appeal process should track the definitional section within the CFR 42. So is it your contention when it says with a right of appeal to a state agency that means a department?
That's correct. It would be the state agency, which is DCH.
So if DCH currently before an ALJ and they're reversed, it goes back to DCH and they can reverse the recommendation, and then there's the petition for judicial review?
That's correct. That is the current process.
And you're saying that the proposed law is in conflict with the provisions that is outlined in 431-205?
That's correct, because if based upon what's currently written in lines 34 and 35, it says that the ALJ's decision, that being the administrative law judge's decision, shall be the final administrative decision of the commissioner, which would be the agency.
And what is your may I ask one more question?
Sure, go ahead.
What is your interpretation of the due process system as outlined in paragraph D?
I'm sorry, I guess maybe I could ask for.
Makes you referring to
Right.
431.205.
Mm-hmm.
Yes, sir. Number D, because if you're spending the time and you're going through a hearing, it's recommended, and it's reversal, but it's recommended to the entity that actually issued the initial decision. How does that follow paragraph D in terms of due process?
Well, keep in mind, when you're talking about due process, you're looking at notice and the right to a hearing. Each of the members and providers are always issued notice regarding any action that the agency is going to take, which would be deemed an adverse action. So that component is satisfied. From that notice requirement, that individual has the right to a hearing, which they get at OSA. In terms of due process, each of the members is in fact getting their due process. And again, if either party disagrees with the agency's decision, they may then appeal to a higher court, which is the Superior Court.
I'm not going to belabor it, but the final decision from the department would be findings of facts and conclusion of the law.
Correct.
That would be different from what an independent administrative law judge would issue.
We have the authority to either modify or reverse or to remand. So it would not be a situation where there is it's more of an appeals process. In other words, you're reviewing the record from below. And so based upon those findings, there's not any new evidence admitted at that point, if that makes sense.
Yeah, I won't ask any more questions, Mr. Chair. I'll wait.
All right,
Okay.
thank you.
Thank you.
Okay, I'm sorry. I hope
No
I answered
problem.
your question.
Ms. Oliver.
I'll try to be brief, Mr. Chairman, because I know there are those that sat on the subcommittee that followed this much more closely than I do, but I used to be a hearing officer myself for OSHA, and I think you could, I don't accept your argument that it's not the final decision of the agency for some of the points you're making, and I think I would make an argument under Goldberg versus Kelly that y'all's reversal of findings of fact from an independent ALJ is a failure of due process. Because I know your reversals are based on evidentiary reasons,
Right.
And that is a failure of due process. So I believe this issue was addressed in the subcommittee and resolved to the, and I'll really ask Chairman Jacobs, was resolved to the satisfaction of the subcommittee that your argument that it is improperly a delegation of a final decision is not something that the subcommittee agreed with. Am I right about that?
I would concur with that.
That it?
Yes, sir.
Thank you. Okay. Anyone else have questions of the two representatives of the Department of Community Health? If not, we'll ask, I think someone else I know raise their hand who may not be on the list, but come forward if you would, and we'll let y'all step back and
Thank you.
have others who wish to speak to the bill. Thank you. Give us your name and who you represent, please.
Sir, thank you, Chairman Willard. My name's Josh Norris. I'm with the Georgia Advocacy Office. We are the statewide protection and advocacy system for people with disabilities in the state of Georgia. We represent a lot of people in Medicaid hearings. A couple of things. The 42 CFR 431-205 requires that we have a fair hearing process, a system. In Georgia, the way we've decided to effectively do that, and I think do that well, is by having the Office of State Administrative Hearings hold those hearings. Well-qualified judges, full and fair hearings. I mean, the whole concept of due process, if I'm not mistaken, is the idea that we have a fair and impartial judicial entity, body, apart from the parties presiding over these matters and making a decision. And in fact, that's what we do have. We have a good process. The problem is that we've got a couple of things, and this is what this bill tries to address. One, we've got cases where people have requested appeals. Now, mind you, those appeals are supposed to be heard and decided, a written decision within 90 days. That's actually required by 42 CFR 431.244. The department has a history, in cases I've been involved in, where they will hold those, and it won't be transmitted over to OSA. Every day it does not get transmitted over to OSA, we cut into their ability to actually have a hearing, render a decision.
Let me ask you, what is OSA?
Oh, sorry. The Office of State Administrative Hearings.
All right.
I get into acronym speak. I'm
Yep.
sorry. So the bill proposes the 10 business days to literally transmit the paper, transmit the file over to the Office of State Administrative Hearings so they can get on with the task of setting up a hearing, scheduling it, dealing with evidentiary issues, having a hearing, rendering a decision. There is nothing that prevents the department to delegate its responsibility to create this hearing system to someone else. They do this with prior authorizations. They've done this with coverage relative to care management organizations. We engage in contracts as a state with a variety of entities to carry out their functions and duties under the Medicaid Act. This is simply one more. I think going to Representative Oliver's point that if we are going to have a fair and impartial process, the core of due process, we have to have what we have now, which is OSA, Office of State Administrative Hearings, having those hearings, and then having that decision be the final decision. If either party is not satisfied with that, they can appeal that to Superior Court, just like we do in all other cases. So that's the other piece to this. Because otherwise what we're stuck with is a situation where we've got a couple of problems. One, you've got that 90-day, not only for the hearing but the decision. I do not see how it is practically possible to have a full hearing, have a written decision, have it back to the department, to then have them do with it whatever they're going to, all within 90 days. It is simply not possible. Secondly, back to the core principle of a fair and impartial hearing. We have it. We're just trying to put some parameters around it and define it.
You support House Bill 229?
Absolutely.
And do you find it deficient as far as the language as to the decision of the administrative law judge being a final decision on behalf of the department?
No, I do not. I think it actually the bill, I think, goes right to the heart of that provision around 205 in demanding and mandating that the state actually have a fair hearing process.
Thank you. Any questions of Mr. Norris? If not, I'm grateful for you coming today.
Thank you, sir.
Excuse me. Anyone else wish to speak on HB 229? If not, I'll close off further public input. The bill is now in the breast of the committee. Do I have a motion?
Do pass, Mr. Chairman.
Motion do pass, and second. We have some discussion.
Yes, sir.
Mr. McKillop.
My only discussion on it, and I wasn't in the subcommittee, but just in reading it and sort of trying to bullseye things, in line 47 and line 50, it asks for the department to do a compliance report, and I know the idea of a compliance report it includes both compliance and non-compliance, but I think what we're really trying to get at there is non-compliance with the statute. So unless compliance is somewhere defined as compliance and non-compliance, I could read this report if I were charged with submitting it as only reporting those cases with which or in which we complied with the time frames. And so I think non-compliance may be a better term there, but that's...
All right, we'll consider that in a moment. Ms. Oliver, did you have yours pushed?
No, sir. I just wanted to make a motion.
All right, we have a motion pending, which is due pass, and it's been seconded. Do we have any further discussion among the committee members? If not, do we have any proposed amendments? Any amendments? Mr. McKillop.
I would move to amend by changing compliance to non-compliance on lines 47 and 50.
Why don't we make it department's compliance and non-compliance?
Yes.
We had a motion then to amend on line 47 to add after compliance and non-compliance. That's been seconded. Do we have any discussion on the amendment? Chair will call for the question. All in favor of the amendment signify by saying aye. Aye. Opposed, like sign. Motion carries. Any further amendments? There be no further amendments. Chair will call for the main question. The motion is a due pass to House Bill 229 as a committee substitute and as amended by the committee. All in favor signify by saying aye. Aye. Opposed, like sign. Motion carries. Thank everyone for being here today. Appreciate it. Thank you. Next we have is Mr. McCall. Mr. McCall present. There he is. Come up and have a seat with us if you would. Representative McCall. Thank you.
Thank you, Mr. Chairman.
We're here on the House Bill 65 and the number, I'm sorry, didn't have mine out yet. We're working off LC 294742S.
Can I borrow one? Because that's after y'all.
Yes, here we go. Here we go. Tell us a little bit about the bill and the history of it.
Well, you calling this thing early is going to get you and Representative Dobbs a hearing on you. On the animal bill.
I'll believe that one. That's it.
No, the gist of what this is if a adopted person wants to see the medical records that is in a sealed adoption file, then it says that the adoption agency shall open the records in order for them to see it. The genesis of this, I told the subcommittee, is my wife and my son who passed away a few years ago. Every time you would go to the doctor with him, first thing they would ask would be what's family history, and it was in a sealed file that we couldn't get to whether there was any in it or not. We didn't know Jane's family history, and I told him just last week when the skin cancer thing was upstairs in 2:30, first thing they asked Jane when she went in there was, what's your family history? So family history is very important to me, but I know mine, and y'all do, and it's just as important to an adopted person. And all this does is say that the information, medical information, shall be made available to either a child, a legal guardian, or a health care agent of an adopted person, and it can go back genetically to parents and grandparents or relatives if it needs to be. This thing has been what y'all call Claibornized, and I agree with what she said. It's fine with me. She just lawyered it up a little bit, and it makes it fine with me.
Now, for the purpose of history, you had this bill last year come through this committee, and it was held up in rules, I believe, correct?
It just ran out of time.
But I recall you going around bragging about the fact that you had a bill come through the Judiciary Committee without being amended.
I was the only human.
Now, this is a substitute, ladies and gentlemen.
Y'all messed with it twice, but that's okay.
You give us a shot at it.
That's okay.
We got to keep our reputation intact.
And y'all have one, promise you.
All right. Do we have questions of the presenter? We do. Mr. Hatfield.
Mr. Chairman, it may be a question for you. Normally, when you do an adoption, there is a requirement in current law that the petitioning party would submit on forms that are prescribed by the department certain personal information relating to the natural parents. Is that what is being referenced in this bill?
Primarily, yes, because what you have,
but it is
unless it's a private adoption, it may not be done through a private adoption, but where you have a state agency type adoption.
Right. Okay.
The information is non-identifying to
to
the parent.
What you're wanting to have is if the family or some member known of the family had say diabetes as an example,
Well,
or
my
some
son
other
had spinal bifida,
spinal
and
bifida or
we
other
went back
hereditary
through
type.
a different way and found out that Jane had what I think would have been a
Yes.
stepbrother that had a problem like that, and we didn't
Right.
know.
Very, very good. Any further questions of Representative McCall? Thank you, sir.
Thank
Glad
you
to
all.
have you with us. And anyone else would like to speak to House Bill 65, the committee substitute? Chair hears none. Is now in the breast of the committee. The chair will entertain a motion. Motion made and seconded to do pass. Any discussion? Any further discussion? None. Is there a proposed amendment? Or
No, sir.
Discussion? Excuse me.
Historically, last year, when it came to the Rules Committee, was there an interest in making the bill structured?
There will probably be a structured bill on this because this is an area that we concern ourselves that somebody may try to open up other things that should not be done.
Thank you.
Yes. Well, all right. No further discussion and no amendments being offered. The chair will call for the main question, which is a motion do pass. All in favor signify by saying aye.
Aye.
Opposed, like sign. Motion carries. Thank you, too. Bringing this to our attention. We will next have Mr. McKillop. I'm going to hold your bill as you're on the committee just for the purpose of having those who are visiting with us today an opportunity to address it first. Representative Black, House Bill 174.
135 maybe?
Oh, did I say 1? I'm sorry. I did pick up the same number. That again, we're picking up district numbers. Pardon me. I'm dyslexic. Go ahead. Come ahead.
Please, the chairman, I'd like to bring up our new colleague, Representative.
Pull your mic down, Mike, because
Representative
we got
Ted
millions of people watching us. And
Yes,
be sure
sir.
they hear everything. Who is it with you?
Chad Nemmer, our new colleague that's just been elected.
Oh, yes.
That,
But will you bring anybody you like up?
prior to this special election, I've probably had more experience and knowledge in the field of forestry than the rest of our colleagues, but now he trumps me.
He
because
trumps you. He's in the business.
He's in this business and he's a professional.
Okay. Well, that's great.
First, Mr. Chairman,
This
I'd
is
like
wrong
to.
one. All right, hold on. I'll just find out something. We got the wrong sub, I'm told, in the folder. Do you have?
It was done last night, yes.
It is ready? Well, we'll send somebody up there. Where's Jason? Where? Oh, it has? Okay. You got to go up there and get out of his folder then. I'm sorry. Would you mind if we stand down on your bill for a minute until we get the right bill before everybody?
Far for the course.
I promise you we won't forget you. And with that being done, Mr. Bearden. Representative Bearden, is he around? Yeah, he's coming up toward the end. All right, we'll move on down. I've got who's in here? Mr. Powell, I know you are. Oh, came close. Came close. All right. Mr. Beard, we're on House Bill 149. Subbill 419, okay. Let me get, so everybody's be sure on the right bill and number.
Okay.
We're looking at LC 294730S. I hope this is the right one.
That's one I got, Mr. Chairman.
All right. Tell us about your bill, Mr. Bearden.
This one's about came full circle, and What we have got right now, the biggest change, and it's a lot shorter bill, is starting on basically line 63. If we go back to line 60 and 61, though, talking about magistrates other than the chief magistrate shall be appointed by the chief magistrate with the consent of the judges of the Superior Court. What we're doing now, lines 63 through 65, is for those magistrates that served on July 1st, 2011, once their terms have expired, they will then start going or working at the pleasure of the chief magistrate. As a subcommittee and this full committee knows, this has gone through many changes. We truly believe this is the best route to go. Also, this best route to assist the JQC with some problems we're having with the budget.
I understand. And let me just, for purpose of disclosure, that we do have, has been raised with us, and I have some concern. We're apparently maybe in an area that by the state constitution we should not tread. By the language that you have, bring over here, Catherine, the Georgia State Constitution for me, please. You got it? You got the section up? Okay. Because what we have is the not the disciplinary part, but I want to get the part about the judgeships, which is under section 610(2), I think. So give me just a second. Who was that, Mr. Bearden, talking to? One of the magistrates?
Sir?
When we were speaking to the gentleman in the office part of it, what you have is a continuation of judges. I'll just read the section. This is under Article 6, Section 10, Paragraph 2. Each judge holding office on the effective date of this article shall continue in office until expiration of the term of office as a judge of the court having the same or similar jurisdiction. Each court not named herein shall cease to exist the date. I'm sorry, that's not the one I'm looking for. Beg your pardon. There is one dealing with Article
6, Section
7, is it? Okay. Yeah, this is, thank you. This is election term of office. All Superior Court and State Court judges shall be elected on a nonpartisan basis for a term of 4 years. All justices of the Supreme Court and Justice of the Court of Appeals shall be elected on a nonpartisan basis for a term of 6 years. The term of all judges thus elected shall begin the next January 1 after their election. All other judges shall continue to be selected in the manner and for the term they were selected on June 30, 1983, until otherwise provided by local law. So what I'm reading here tells us that the only way we can change the terms of a magistrate as those all existed on June 30, 1983 would be through a local law provision, or we would be in violation of the state constitutional directive as to their terms. I'm sympathetic with what we want to do. The question is, are we capable of doing it and not be in violation of the state constitution on that point? What say you, Mr. Davis?
Mr. Chairman, I don't know what the term of the magistrate judge was in 1983, but I assume it's the current law.
I'm suggesting that's what I think it was, because all the magistrates were set up as a matter of the judge elected as a magistrate back in the 70s. So the issue about having associate magistrates, I'm not sure. If you didn't have associate magistrate until sometime after 83, would there be a difference? The question I raise here is the fact they're selected in the manner and for a term, to be selected in the manner and for a term, as was the provision on June 30, until otherwise provided only by local law.
I'm sorry, I was about to say, reading the Constitution several times in the past and hearing what you're saying, and unless I'm missing something, it sounds like we're discussing the elected portion of the magistrate, which I would completely confer with the Constitution on the elected part. As we know, and I'll use the term associate magistrate, but the magistrate that's not the chief is not elected.
True, they are appointed.
Correct.
They are not elected. They are appointed. But it says all other judges shall continue to be selected. It's elected, selected, in the manner and for the term they were selected as of the June 30, 1983, unless otherwise provided by local law. And that's the question I raised about it. And they had a case dealing with, of course, a provision on magistrates, but I don't think it touches on the specific point we have. I think what we'll do is go ahead and proceed with the discussion. I think everyone understands the concern we have, and if we take action on the bill, it may be subject to getting out of rules once I've satisfied myself on this constitutional question. All right. Does everyone on the committee understand what we're facing here? And I say this: this bill has been through several gyrations, changes, and what we came down to was doing similar to what we have with the juvenile court judges, because all of them who are associate are done on the basis of you serve at the pleasure of the juvenile judge. Same thing, I think, with the probate judges, where we allow those now to be associate probate judges. I think DeKalb has one, do they not? Mm-hmm. They serve at the pleasure of the probate judge. And so why not have magistrates who are appointed serve at the pleasure of the magistrate judge? Same system. Correct. With that concern. That addresses the question.
That's the question.
Does anyone have any questions of the presenters? If not, is there anyone else who would like to address the committee on House Bill 149? Come around if you do.
Thank you, Mr. Chairman.
We've got Mr. All right. Good point. Well, thank you. Yes, sir. Give us your name and who you represent.
Thank you, sir. My name is Mike Cucaro. I'm with the Administrative Office of the Courts, and we serve the Judicial Council of Georgia. I've come here today to simply reiterate the Supreme Court's offer to work with the Judicial Qualifications Commission and the Council of Magistrate Court Judges to deal with the issues that gave rise to House Bill 149 under its rulemaking authority in the Constitution, which is granted by Article 6, Section 7, Paragraph 7. That offer still stands.
All right.
Thank you.
Any further? Anyone have questions of Mr. Cucaro? If not, is there anyone else who would wish to address the committee on House Bill 149? Yes, sir.
Thank you, Mr. Chairman. I'm Charles Austin, a magistrate, Athens, Clarke County, legislative chair for the Council of Magistrate Court Judges. Mr. Chairman, thank you for the issue that you pointed out. That was an issue that the council also had a concern with. I do want to let the committee know that Jeff Davis came to our committee, to the entire council back in December, and brought up the concerns that he had. We formed a committee within our own council to look into the concerns and how they can be addressed either internally, the Supreme Court, or legislatively. I offer to Jeff Davis that no matter what happens with the bill today, that we're still open to sit down with him and try to see if we can work this out outside of the legislative process to address it. Invited him to come to our council meeting. I think we've invited him to come to our trainings. And so we're just saying we might be able to resolve this outside the legislative process, especially since the issue you raised, sir.
Let me ask you this as a matter addressing the bill, and I guess you would not be able to speak on behalf of the Magistrate Council. I don't think y'all taken a position, have you, on the bill?
Well, we've continually opposed it for many reasons, but we just got the bill a few hours ago.
Okay.
So we haven't voted on this particular.
But now, have you voted in the past as to the legislature addressing change of terms for associate magistrates?
Yes, well, with regard to the initial bill, we did vote to oppose that as well as written.
Well, I'm asking, if we pass the bill out in its current form, we are looking at the language about the associate magistrate serving at the pleasure of the elected magistrate.
Yes, sir.
And you're saying on behalf of those who are the elected chief magistrates, they do not want to have that as a potential tool, might say, to be sure you don't have a recalcitrant associate that doesn't follow the needs of the office?
I think there would be a lot of chief magistrates who would be interested in that, but I do know there's many chief magistrates, especially Judge Moss, who's come up here and testified against it, who's an elected chief, who would not be in favor of it. The elected chief I work for is not in favor of it.
Okay.
Yes, sir.
All right. And we'll take that as hearsay, but I understand it be the point. All right. Any questions? If not, we appreciate it. Anyone else who would like to speak on behalf of the House Bill 149? Here's what I'm looking at also, as brought to me by Ms. Travis. And I'm saying this in the sense that I'll reiterate what I stated earlier. The statute 151020 has been in effect since, of course, back before the 1981 code. And there were changes, and it may be that the changes that came to this bill afterwards back up. I want to check and see if the original bill, the original legislation, provided for terms in here. If the bill that we have, or I'm sorry, if the law that we have did address terms, then I'm of the opinion that we have the ability through general law to change that as to these associate judges. Correct? That's what we're looking at, Ms. Travis?
I think I would say if 151020 was enacted after the Constitution that provides for that June 1983 Act, then there would not be a conflict.
I'm reading it differently. If the provision was in effect as of the time, I'm saying the provision, which is the statute that we have dealing with the magistrate courts, 15-10-20, right, and addressed the term of courts, was in effect prior to the adoption of the 1983 Constitution, which was June 30th effective date, then we do still have the ability. No?
I think the bottom line, I think we need to go back and look at the legislative history of when D was put in. When subsection D was put in, having to do with the terms.
Correct.
And then go from there.
Well, you had a change, we know, effective in 1984, because unless otherwise provided by local law, all magistrates taking office after January 1, 1985, etc., shall be selected. So we know that something occurred in 84, addressing that point. And there was an 84 change, I see.
Right. The way I'm reading, I just looked at it real quickly, the legislative history, the whole code section wasn't enacted until 1983, which means the constitutional provision says that all other judges shall continue to be selected in the manner and for the term they were selected on June 30, 1983, until otherwise provided by local law. So it seems to me that if they didn't come into existence, that this provision wouldn't apply.
Okay.
So, but I might not be following it right. I'm coming late to the table.
Well, what we're going to do is we'll consider the bill. If it does pass out, it'll be subject to getting a resolution on that question out of Legislative Council before we ask for it out of rules. Is that understood? Yes. All right. Further discussion. Anyone else wish to address the committee? If not, the bill is now before the committee, the rest of the committee, and do we have any motions? We have a move to pass. Is there a second to the motion? And seconded. Do we have any discussion on the motion? Do we have any amendments to present? There being no amendments, the chair will call for the main question. All in favor do pass on HB 149, signify by saying aye. Aye. Opposed, like sign. One no? Did I hear no? Okay. Chair rules the motion carries and the bill is passed on to rules. Thank you. And we'll get you an answer hopefully on that whole issue. I'd otherwise hold up, but we're just at a point in time where we can't hold bills and expect, yeah. I'm going to turn now the meeting over to Mr. Jacobs to continue to chair until I return. I've got a bill I need to present.
Oh, okay. All right, that's fine. All right, Jeff is passing out House Bill 135, but while he's doing that, I'm going to call up Representative Powell to present House Bill 455. Representative Powell. Oh, hold on, Mike. Pull your mic to you, too.
Bring to you House Bill 455. This is a rewrite of certain provisions. It's clarifying language in the unfair trade practices for the real estate profession. The current language seems to be a little bit too broad in its interpretation. Under the current language, it says that that real estate professionals that they will disclose the amounts of referral fees. And unfortunately, in the real world, the real estate business, that's not known until a transaction is completed. So what we're proposing in language in this is that the broker disclose whether or not he is receiving a commission or a referral fee. Also, other language in here that says that current law says that they'll disclose all expenditures. Well, in the real world of practicing real estate, MLS fees, newspaper ads, and things like that is just part of doing business. It's not part of, and we don't think that should be disclosed or at least itemized.
All right, questions for Representative Powell? Seeing none, I do want to recognize Chairman. We have a sub in front of us. Is there anything in particular we need to know about the sub, Chairman Lane, or that was done in subcommittee?
I don't remember us doing anything to it in the subcommittee.
There's a sub that was presented by council that said it was only a technical language, and I think that was adding the official Georgia code annotated into the caption.
All right.
Yeah.
Okay. Let's see if we have anyone. There's no one. No one's hit their button to ask you questions. I don't have anyone signed up to speak on the bill. Does anyone want to speak to House Bill 455? Mr. Hatcher? Because we have millions of people watching us.
I'll try to be very brief. I just wanted to support Mr. Powell's explanation of the bill. I appreciate his efforts. We worked very closely together with the Real Estate Commission. What we have done for many years now as a trade association is try to work in conjunction with the Real Estate Commission so we can come to you and say that the practitioners and the regulators are on the same page. And I'm proud to announce again today that's what you have in front of you. Obviously, as policymakers, it's your power to decide. But I do have the brand new Real Estate Commissioner here today, and they have voted unanimously to support this legislation. So we just wanted to urge your adoption, and I'm happy to answer any questions.
Questions for Mr. Hatcher? Seeing none, thank you for joining us today. All right. Anyone else to speak to House Bill 455? Seeing none, we'll close off discussion on the bill. The bill is now in the breast of the committee. Is there a motion? Is there a second? There is a motion due pass and a second. Any discussion or amendments? Any discussion or amendments? Seeing none, the chair calls the question to give a due pass recommendation to House Bill 455 by committee substitute LC 36-1888S. All those in favor say aye. All those opposed, no. The motion carries.
Thank you, Mr. Chairman, ladies and gentlemen.
All right, next up we've got House Bill 135. We now have the correct version of the bill. And that's 20. Where'd Ms. Travis go?
94, 45, 26S.
Ah, okay. All right, so we are working from LC 944526S.
If you got an extra one, please.
might want to give the author his bill.
Just in the case.
Representative Black.
Thank you. First off, let me thank Chairman of the subcommittee that has vented this and all the consideration he gave to all of the questions that was raised. And I also want to express appreciation to a couple of colleagues here that helped get some of this legalese. I think we've got something that is beginning to make sense to me, at least. I'm still going to defer to the legal minds that around this table, and I also was of the understanding that the chairman had some different language to put in on this section up here. Are you familiar with that, or?
Well, I'm not. It did not come through my. We'll give Mr. Nimmer a copy of the bill as well.
Well, I'm sort of at a loss as to whether to proceed with this, because we had this sub has some language on the clearly marked line defining it. My last conversation with Chairman Willard is he wanted to go back and have just a simplified statement that says a clearly marked and visible line.
All right. Chairman, this bill came through Chairman Lane's subcommittee, so I'll let him speak to the posture of the bill.
Yes, Mr. Chairman. Chairman Willard did indicate wanting to put some changes in it. We passed it out in the status that it's in right now.
Okay.
And I think that was in agreement with everybody on the subcommittee at the time. Whether Chairman Willard intends to continue to make another change to it, I don't know. He hasn't spoken to us since I think Representative Black talked to him before we had our subcommittee meeting. I think it's ready. I think it's ready to be voted on, but I'd like to have Chairman Willard here to make sure, because he did have some reservations about the amount of language that had been added to it, trying to define what a boundary line is and how you determine that. So,
I will raise one other point that we really didn't get into in depth in the subcommittee, but I've had more feedback from the forest industry, and they have. I think there's getting to be a consensus that the provision over there on section, I believe it is, where is it, about the 6 years? Section 1, A1. I think the consensus I'm getting from the people in the industry, they'd like to keep it at 4 years, is the way the current statute provides.
Well, what I'm inclined to do, and I've got Representative Weldon lit up. Is there something you want to address before I suspend on the bill? Because I'm going to suspend and wait for Chairman Willard to come back. And
I think that'd be good.
I think that's a good idea, and I hope he will be back. We're kind of coming to the close of the agenda. I've got 2 more bills and 1 author who's not here. So why don't we suspend and wait on Chairman Willard, and we'll get this worked out. I'm sorry to do that to both of you.
It's only been going 2 years now.
I'm getting accustomed to it, folks.
Well, you're getting paid for it, aren't you?
Okay. Okay. So we've suspended on House Bill 135. Why don't I go ahead and call up House Bill 419, Representative Mitchell.
Thank you, Mr. Chairman, ladies and gentlemen of the committee. You'll find before you House Bill 419 as substituted by the subcommittee. I can assure you that the bill has been well vetted. Very simply, what the bill does as is before you. At present, if a consumer gets behind in their mortgage, they're at the mercy of the mortgagor, the lender, if you will, to be able to make those payments to get current in their mortgage. What this provision simply does is gives the consumer an absolute right to cure their mortgage. They are willing to pay the late fees and the cost to the business, to the lender. They have the absolute right to cure their debt and get current with their mortgage. If it would be the will of the committee, I must ask Mr. Chairman, I believe the bill is a good bill as is now. Would be a perfect bill if we could also extend the notice provision for foreclosure. My bill is originally submitted lengthened the notice provision to 90 days. The subcommittee and its wisdom chose to eliminate that provision, and certainly if anyone sitting here would like to extend that notice provision, I certainly would not object, but provisions are before you as we speak.
All right. Any questions for Representative Mitchell? Seeing none, thank you for joining us today. Anything else you want to say before?
That's it, Mr. Chairman.
All right.
I would certainly request your favorable consideration to pass this for this committee.
I don't have anyone signed up to speak, but I would bet Mr. Stubbs wants to address the committee.
And get onto the list. I apologize, Your Honor.
That's okay.
I'm going to hand out something that was handed out in the subcommittee, if I might, Mr. Chairman.
Mm-hmm.
My name is Tom Stubbs. I am an attorney in Decatur. I've been involved in foreclosure-related litigation since 1991. I've almost always represented the debtor, though I actually have represented creditors as well on occasion, including Chemical Bank across the state of Georgia. The bill is a good step and a good thing, but I wanted to explain to you, number one, why it's not that great a deal, and why and how it can be dramatically improved. What you've got in your hand is a sheet that has at the top a long, densely worded paragraph. Remarkably parallels the rights that you're just about, hopefully, to adopt in Representative Mitchell's bill, to reinstate as long as the payment is received within 5 days before the foreclosure. Looks really a lot like that. Well, you wonder why the banks are okay with Representative Mitchell's bill? It's because this provision is in every Fannie Mae and Freddie Mac contract already. What the bill simply does is enshrine in law what those entities using Fannie Mae and Freddie Mac are already obligated to do. And they're now simply forcing that onto, by law, onto the other lenders. I'm in favor of it. It's good to have. But make no mistake, it's not a big concession. They're already obligated by contract to do it. And I guarantee 99% of the people in the state who have a security deed have no clue that they have that right. And that goes to the second part on that sheet. Below that, and you'll see an exhibit sticker next to it because it's actually a letter being used in wrongful foreclosure litigation, is the typical paragraph that a debtor gets in the connection with foreclosure. And what does it tell them? It tells them, you didn't cure your arrearage, and now the entire loan must be paid off. It's called acceleration, for those of you who don't know the term. We accelerate the note, and you have to pay $150,000 or $175,000 or whatever the entire amount of the note is, or we're going to foreclose, generally in less than a month. No mention anywhere of the fact that in that same contract, the person has the right to reinstate. And it's in this person's security deed. It's in most of them.
And I get, as I told the subcommittee yesterday, I get probably anywhere between 2 and 10 calls every day from people who are losing their homes. Most of the time I can't do anything for them. Most of the time they should get out. They can't afford it. But every once in a while you hit somebody who actually can come up either themselves with the money or through an uncle or aunt who's got some money that can help them through a short-term problem where they are able to sustain the finances in a long-term way to keep up the loan, and they can cure it, but they had no clue because they've just received a letter from the creditor saying the only way they can get out from the loan is to come up with the whole amount. Well, that's just not it. I say, let me see your security deed. Look at this paragraph. And we come up with the money to cure it. And that leads to what I wish would be in there. As originally, well, and I should say, and as a result, every once in a while I'm able to help somebody save their home because they can reinstate. But you can imagine the pitiful fraction of debtors who are in trouble that actually reach out to an attorney that kind of knows this stuff. Most don't know it, and most don't reach out to an attorney to begin with, and they lose their home. Now, again, I'm not for anybody keeping their home if they can't afford it. I'm not for stiffing the banks. I'm not for doing anything. But simple information would be a huge help here, and it's a relatively costless thing to do. I'm going to hand one second thing out with the permission of the chair that I handed out yesterday. And unfortunately, this provision was written in connection with the original draft of the bill, but it provides the kind of language that the committee could adopt as part of this bill that says if you're going to send out, you being the lender, is going to send out a notice saying we're accelerating the loan, and there's nothing in the bill that you're about to adopt. Representative Mitchell's bill does not change anything. Creditors will still send out that letter that says pay off all the loan or we're going to foreclose. They're never going to change that letter unless you tell them they have to. And that's what this does. It provides some language that if a creditor sends out a letter saying we're accelerating the loan and we're going to foreclose unless you pay off all the full amount of the debt, that they then must also include any other contractual or statutory rights to cure that the debtor has. So they've just got information. We're not changing the balance of power anywhere. Whatever rights the committee agrees to have by law, whatever rights the parties have agreed by contract, they're set. I'm not changing it. I'm just trying to get information, and information is power. If you can give the debtors that, by far and away the majority will still not be able to rescue their homes, but there will be some that can, and it seems to be a small price to pay. I would also strongly suggest that the term creditor be defined. As used in this bill, it does not define the term creditor, and believe it or not, that kind of gets messy. If you look at Frank Alexander, the professor at Emory who teaches property law and written the book on Georgia foreclosure, he talks about who has the right, who has standing to foreclose, and it's the entity or person who owns the note and the security deed. That's what the combination of those two give you the right. The note, because that's where you have the obligation that when it's breached, you've been damaged. If you just have a security deed, you don't actually have damage. So to give your standing, a creditor needs to have the note and the security deed. And in order to clarify this, in order to avoid litigation, frankly, it would be useful, much as you've defined here the term security instrument, that a provision be added also that would define creditor. And here is a proposed language that does that. Again, that's not in favor of anybody, but it simply avoids something that's going to be fussed about in this world. At any rate, the bill is very good and a very good step. It provides by statute a right that is already available to many debtors contractually. It's important for you to know about that contractual arrangement for two reasons, though, so that you recognize this is not a big concession by the banks. It's simply they're trying to get the folks who are outside the Fannie Mae world stuck with the same obligations they have. And second, you see that notwithstanding the fact that they've already been operating under that obligation, in their communications to debtors, they misleadingly tell the debtor what has to be done to stop the foreclosure. They tell them the only way to do it is to pay the whole debt, when in fact there's a contractual right to cure it just in the way this bill provides. And I would urge that you get that information to the debtors, which you can do. I share Representative Weldon's concern that, you know, you're responsible for what you have in a contract, and I don't want to change the rights of people, but providing information is power. And that's all we're doing here, not altering the rights of anybody, but just getting the information so that it's there, so that there's a communication of, when there's a communication about what's about to happen in the way of foreclosure, that the communication is not one-sided, that it clarifies what the situation is for all parties. And that's just a suggestion based on my experience in doing wrongful foreclosure litigation. I'm going on 18 years now. It would be a help. Thank you, Mr. Chairman.
Sure. Questions for Mr. Stubbs. Representative Evans.
Thank you, Mr. Chairman. Mr. Stubbs, thank you for all this information. I am curious if you mentioned that it would be good for us to define the term creditor in this code section. Do you think that the term creditor needs to be defined elsewhere or just in this one section?
It would be nice to define it elsewhere. It's actually an issue that's being heavily litigated, but before you right now is one section, one place, and it would be useful just to have it here. Debtor is actually defined by statute in here. You don't find a similar definition of creditor.
Thanks.
But Frank Alexander talks about the importance of unity of the note and the security deed as the defining characteristic of what a creditor is that has a right to foreclose, and that's what you would have in this definition.
Thanks.
Right.
Representative Stevenson.
Thank you, Mr. Chair. And thank you, Attorney Stubbs, for all the work you do on foreclosure. I'm very supportive of this bill. In addition to your comments, I have a question. This bill has been carried over from a couple of years now, and I have the same question I had then as it relates to Section F as to the ability to cure the default, lines 41 through 46. Would that provision supersede a security instrument provision? And if so, because that to me limits the ability to cure.
I think that's a good point. Certainly, for going forward, you'd have if you have a contract written different than this, and you have the language in G that it can't be waived by contract, then a court might say this operates as a floor, not a ceiling, but certainly a creditor would have a pretty good argument that this operates as a ceiling as well. So I think you're exactly right that even under the standard Fannie Mae contracts, this would not go because they don't have a limitation like this. You can see it. It's in what I handed out.
Thank you.
Representative Oliver.
I wasn't at the subcommittee, so I'm trying to put together what I remember about this bill from last year and what I remember about the 90-day provision. Is it fair to say that all of these amendments were considered in subcommittee or discussed and possibly voted on?
They certainly. I presented these very same ideas at the time, and yes, the subcommittee did consider them, as I understand it.
And the author likes the amendment about 90 days, but he may want to offer an opinion about your other suggested.
It's absolutely welcome. I've shared these notions with Representative Mitchell as well.
I think it's consequential. I think it might even be a good idea to define the term. Anything else, it would be at the place of the committee.
Do you have an opinion, because I have no idea, if Fannie Mae and Freddie Mac go away, what happens to their
uniform contracts?
Yeah.
I suspect they'll still be used as a custom, although I imagine at the moment they're not obligated to do so, the creditors will stop including that provision.
So the statute would, in effect, help the borrower when I think I perceive most of the commentators say Freddie Mac and Freddie Mae will go away, but may be reinstituted may or may not be reinstituted in some other entity.
That's right. And which reminds me, to address similarly the Representative Pam Stevenson issue that connects to your question, you could amend subparagraph F to where it talks about the guaranteed opportunity to cure. You could insert in there somewhere, if not already provided by contract, would then protect any contractual rights that are greater. than the statutory right authorized here.
I found just one final question, and somebody at the table may know this. If you don't, what happened last year on the 90-day notice provision and all the foreclosure?
Last year, the committee was much more generous than they were last time. I think we got it to 45 days, Mr. Chairman.
You're speaking of Senate Bill 57. Well, ultimately everything got folded into Senate Bill 57, and there were so many different versions of that bill that I can't remember what ultimately came out. I believe we did have some.
Yeah. Which I was so intimately familiar with it. It got to 45 days last year. You know, Mr. Chairman, if I may, to speak to Representative Oliver's question, foreclosures have certainly no less been debated within that time. And as much as the wisdom of the committee was 45 days was sufficient to move it last year, certainly that was not 60 days or 90 days to be appropriate
Okay.
this year.
Let me get you to hold up. I'll let you come back and talk to the committee. Did you get your question answered?
Yes, sir.
Ms. Oliver? Anyone else have questions of Mr. Stubbs today?
Thank you, Mr. Chairman. Thank you.
Appreciate you coming before us. Anyone else wish to address the committee on House Bill 419? If not, we'll close off further public comments. The bill is now in the breast of the committee. We're working on LZ 294750S. Do we have a motion? Move do pass. Do we have a second? Second. It's been moved and seconded. Do pass. Do we have discussion on the motion? Do pass. Do we have any amendments? Yes, ma'am. Who was that over here? Push you, Ms. Stevenson. Thank you.
I do, but I would like to ask the subcommittee chair a question regarding that subsection F. As to, I'm not sure the intent. It certainly, to me, supersedes an instrument the way it's outlined.
I think it would be fine to take it out. It was added in. We had 2 hearings on the bill. We had a hearing yesterday, late yesterday afternoon. Then we had a hearing this morning, and in response to a question from Representative Lindsay, we added that language, and it was actually imported from an old version of Senate Bill 57, where just about everything gets lifted from these days in this area. So, but the way it does read in context with subsection G, you know, to the extent that there are provisions in a contract, I mean, they may ultimately end up superseding that. If your motion is to remove subsection F and to re-letter accordingly, I'll support you on that motion.
Thank you. That is my motion.
And I'll second that.
Thank you.
Motion is to delete in its entirety section F, and that's lines 41 through 46.
Yes, sir.
Renumber 47 to F and 48 to G. Is that correct?
Yes.
All right, that is a motion. Do we have a second?
Oh, second. I'll second.
We have a motion and a second. Any discussion on the amendment? No further discussion on the amendment. Chair will call for the question. All in favor of the amendment signify by saying aye. Aye. Opposed, like sign. Motion carries for the amendment. Any further amendments? Ms.
Mr. Chairman, thank you. I might, but I also missed part of the subcommittee meeting yesterday, and I would like to ask the subcommittee chair whether or not they discussed adding the term creditor to the bill, and if not, why not?
No, actually, no, not at all.
It wasn't?
This was not presented yesterday at all. This
right.
is this packet was, but this sheet was not. and it'd be, I mean, I don't have any particular opposition to that either.
Then, Mr. Chairman, I'd like to move that we add
definition.
The definition of the term creditor as on line 5 through 7 on this piece of paper, under the term of security instrument on, I guess that would be beginning on line 15.
Well, let me, can I help you out, Representative
Certainly.
Dobbs? The way that Ms. Travis ordinarily likes to do this, we would start off subsection A, as used in this code section, the term semicolon, and then we would move down to paragraph 1. Security instrument means a mortgage, security deed, or lien contract, semicolon, and creditor means the person or entity that owns, and then you would continue on with the balance of that, and that would be paragraph 2. That's how.
Thank you, Representative Jacobs, and I so move.
All right, and what will
I'll make that's a motion.
I
Already there's a
I
you
move.
made the motion.
Move second. I would also add to the motion, just as a matter of clarification, we will allow, with the committee's approval, Ms. Travis to put it in the proper format. All right.
Absolutely.
And we have a discussion on the amendment. Mr. Weldon?
I don't think I understand what the how we're going to define creditor very clearly. I'm not sure. We're just going to put up here security instrument. I'm going to move it down. And then 2 will be, where are we getting that? Oh, from right here.
What she's doing is adding in, by her motion, the definition of the term creditor, as that term is used in the language of the bill, but is not a quote defined term. I think most might recognize what it is, but not harm to have it. As I read it.
Okay, could I comment on the definition here? And maybe I just need some guidance on this. There are.
Speak to the amendment.
Thank you, sir. I think that somebody has a promissory note. They'll take they can take the interest stream, and then they take the principal stream of income, and they sell those on a market, and then in the event there's a bankruptcy or something like that, then you still have that underlying security deed out there where someone could take an interest in the property. And if we define it to mean the person or entity that owns and holds the security instrument and the underlying note, that sounds conjunctive, and yeah, I'd just like to think about how that's going to be addressed and how that will be. I mean, that looks like it could be a problem for what we're trying to do in this statute.
All right. We have other comments, I believe.
Since I'm no longer a member of Subcommittee 2, my thinking on this topic is a little bit blurred, but at the risk of being hyper-technical, the amendment that's proposed refers to a person or entity that owns and holds a security instrument and the underlying note by virtue of which the person has the power of sale. Is there any concern that reference might be interpreted to the note conveying the power of sale, which of course would not be the case? It would be the security instrument. Is this of significance? Should the order of the terms be reversed?
You asked that to subcommittee chair.
Well, I think it's correct that only the security interest would contain the power of, only the security instrument would contain the power of sale. I don't really, frankly, I don't even know that there's a reason we need to reference the note. Right?
Professor Alexander respectfully would disagree that actually the power of sale is ineffective
saying a standing when you bring a lawsuit, you must have had some injury. The injury derives from failure to pay the note. And you must have unity of the ownership between those two. So the question's a good one. You want to make sure that the reference is to the person owning both of them. And whatever grammatically works to show that is fine. That was intended there to capture both of them. But at least according to Professor Alexander, there is required ownership of both of those to have the power. The power of sale, owning the security alone does not actually give you standing.
Okay.
That's the basis of it.
Ms. Evans?
Thank you, Mr. Chairman. I think that defining words is usually always a good idea, but I did just want to express some concern to the committee that this issue of when what a creditor is and when you might be able to actually foreclose on something by having the note and the deed separated is a very, very hot topic in litigation right now. There's been some cases in other states who have come down. There's different opinions, and I just think that if we define this in this one section, we might make enough people nervous that we end up killing this bill, and I would hate to see us do that because I think the author has great intentions and we want to see it go through. So I just wanted to express that concern because it could make a lot of people really, really nervous.
All right. Mr. Weldon.
Thank you, Mr. Chairman. If I could address this to Mr. Stubbs regarding his comment on that. And also to Representative Evans. So what the way I understand it, you're saying you can't foreclose on a security deed unless you have the promissory note also.
As Georgia laws developed, based on standing issues, the requirement to foreclose has required a injury, and that comes from failure to pay the note obligation, so that you have to have those two. So the answer is yes, and that's not just me. That's.
But you're tying the two together based upon the right of ownership of the security deed has to be coupled with the note.
That's exactly right.
Why do we just stop saying the term creditor should mean the person or entity that owns or holds title to the security instrument?
If they don't own the note, then they don't have the power to sale.
I'm saying that they don't have the power then. So we understand there has to be the coupling, but do we have to address it within the definition?
I think if you do that, you really risk the problem here, because then you'll have gone completely contrary to what you'll suggest by the definition, that a security deed may somehow, standing alone, provide the power to foreclose. And that is not, I don't think, what you want to do. I think the point is made that if the definition under Georgia law should be the two are unified. This comes up principally in the MERS context, where they have no interest in the note.
Yeah.
They have no interest, and you'll notice MERS has issued an order no longer allowing foreclosures in its name in the state of Georgia, anywhere in the country, because of that issue has created a problem for them. So they've acknowledged there's an issue. But it would be better by far to get this out and not worry about the definition. But if you do the definition, it needs to have both the note and the security deed.
Thank you. Ms. Dobbs?
Mr. Chairman, in lieu of what has been said, I think it would be in the best interest of this bill to just withdraw my amendment.
Fine. She's offered to withdraw the amendment. The second agrees?
Yes, please.
The amendment is withdrawn. Do we have any further amendments? Mr. Crawford, do you? Or with the Jew? I'm sorry. I never can tell exactly which one there. Pardon me. I don't understand.
Dress a lot too.
You're prettier.
I have to disagree with the gentleman.
That's right. I'm sorry, Ms. Oliver. Go ahead.
I have a much simpler amendment, I think.
A simpler amendment. Okay, let's try it. What's your amendment?
I would like to insert 45 days wherever 30 days is set forth in 44-14 162-2.
I think you're going to need to reference wherever they are because I'm not sure.
I don't think it's set forth in the bill. I don't think 162.2 is in my draft of 4750. So I'd be
I think what we've allowed here is up to the 5 days prior to the foreclosure occurring, there's a right to open up to pay up what is the arrearage and expenses are tied to it.
Yes, sir. And my amendment is not about curing. It's about notice of intent to exercise power of sale on a mortgage, right, which is, I believe, 44-14-162. So Mr. Jacobs is going to help me here. I offer an amendment that creates a second section of House
you got it
Bill
worded out.
419 and amends section 44-14-162-2 to create the time period of 45 days of notice of intent to initiate foreclosure.
25 days what? I could hear you. I couldn't hear all of what you said.
45 days instead of 30 days to initiate notice of initiation of proceedings to exercise power of sale.
Okay. So
I'm happy for you to help me or correct that if
I think what Representative Oliver wants to do, which could be done via pretty simple amendment, would be to insert a new Section 1 in the bill that would amend Code Section 40, subsection A, because it doesn't appear anywhere else, subsection A of Code Section 44-14-162.2 that would strike the one occurrence of 30 days in that code section and replace 30 with 45.
Yes, sir.
And renumber the sections accordingly.
And I have modified Mr. Stubbs' suggestion as to 44-14-162.2.
I'm going to require that to be in writing so we can see it. You got it?
Okay. It's basically that. I mean, the code sections, the subsection's bigger than that, but.
What's the current law say?
It says 30, I believe.
Okay. So you're changing is under 44-14-162.2. Does everybody have a copy of this document? I'll call it the Stubbs Amendment number 1, I guess it is.
Slightly modified to just only include the first page down to.
Don't Stubbs, sit down, please. Go make some copies of this for me. We're going to suspend further consideration of House Bill 419 until that comes back and everyone has a chance to read it. Chair will call on. Did we get the amendment, the change that you had, Mr. McKillop, in your folder?
That was for 135.
I know. Have you?
Yes.
Is it there?
Yeah,
Blacks?
130. That's 135.
Has it been published?
Everyone has it, yes, sir.
Everybody's got 135. We'll call up House Bill 135. And Mr. Black, Representative Black, glad to have you with us.
Well, thank you, Mr. Chairman. I have been informed that I might be just fixing to set a record.
You might be what?
Just fixing to set a record.
Set a record? How's
yes,
that?
sir, because no one can remember a member or a representative being able to be before the Judiciary Committee in the House 3 times in the same meeting with the same bill.
That may not stand.
That's right.
I'm sure we can break that record soon enough.
All right, I've got 135 in front of me. This was the. What number are we working off, Mr. McKillop, please?
94-45-26S.
Thank you. I do have that bill, and I'll let you lead out, Mr. Ellis. Black.
Well, first off, we've got some new language back over here that our distinguished colleagues, remember your committee has prepared back in section 6, having to do with the legalese of this, that I think takes care of some of the concerns that was brought up in subcommittee. The only other thing that was you and I had talked about, you had some changes in the language on section 4 I believe that you wanted to.
Yes, sir. I think we talked about the clear and visible marking of a line. And I'm looking down the line. It's actually starting on line. An owner of land shall not be liable to neighboring landowners for damages caused in the harvesting of timber if the owner has clearly, accurately, and visibly marked the boundary. So we'll say clearly, strike out, and accurately, and now put and visibly. Mark the boundary lines of the property in the area where trees are to be harvested. So putting pins down, what I'm pointing out is, we're not going to be the clearly marking. You've got to have something visible that tells you this is where the line runs. So people harvesting trees need to know what is that line. Would you agree?
Sure.
Now, go ahead and present your bill.
What
are we doing?
Only other thing that I have got more feedback from people in the industry, and it appears to me to be a consensus that up in Section 1, where the 6 years is put in, I think the industry would be more comfortable if we kept that at 4, which is already in statute code.
All right. And what else? That's it?
That's it.
Let me give you a little history. Members of the committee may not recall, but this was a bill introduced last year. It did not get out of our committee. It came in sort of a late date, and we decided there was some major things to be considered on the issues addressing harvesting of timber, cutting of timber, and wrongfully cutting of timber. There have been a number of issues addressed, and one of the things was the difficulty property owners had with seeking recovery of damages when these events occur. So that was one thing we were trying to address, and the other part that Mr. Blight mentioned was the fact that people go out there cutting trees may not know exactly where the line runs, and the issue is about the responsibility, duty of the owner to be sure before we allow someone to come on his property that he has accurately and clearly and visibly marked that line, as we call it, so that those people doing the cutting and harvesting know where that line is, and if they go over that line, they do it at their own peril and not the peril of the landowner. Mr. Demmer, will you have something to say about all this? I want to hear from you. I want to hear from you. If you present a bill, best day of my life, as some people say. Are you pleased with the bill?
I'm just tickled.
Tickled, all right.
Change it to 4 years. I agree with that. It needs to be at 4 years instead of 6. And okay. I think the owner, just like you said, the language in Section 4 describing clearly marked is fine. I mean, we deal with this every day, and the owner can have that done.
Right. Let me be clear about the Section 1. The current law dealing with trespass is a 4-year statute of limitations. And what we were doing here was setting up a further time frame for this type of trespass where someone cuts timber. And what you're saying, the industry, property owners, everybody says, no, leave it at 4. Just let it alone.
That's the consensus I'm getting.
Okay. Do we have any questions of anyone of the presenter? You do? I'm sorry, go ahead.
To Mr. Nimmer. Mr. Nimmer, can you tell me what the reason is for the 4-year limitation, not a 6-year limitation?
Yes, sir. By the time 6 years comes around, you've got so much vegetation that's grown back up, and the stumps have begun to decay. You can't really go out there and determine what was cut and what the size of the stump, which would determine the size of the tree that was removed wrongfully. And the vegetation's grown up to a point where you can't really determine what was out there. So at 4 years, you just need to leave it at that before the understory gets back.
Are you involved in this type of industry?
Yes, sir.
What's your involvement now?
I cut the trees.
Okay. So you a cutter, huh?
Yes, sir.
You don't want going over there crossing property lines and taking trees. Is that what you doing?
Only when it's bigger wood.
All right, we're getting some truthful.
I buy and sell. We have a brokerage and also have the harvesting crew, so I deal with both aspects of it, the brokering of it and the actual harvesting of it. So.
Okay.
All right. Over here we have Mr. Lane.
Yes, Mr. Chairman, Mr. Representative Nimmer, welcome to the Judiciary Committee.
Glad to be here.
We share Wayne County, so he needs to be indoctrinated. I think the 6-year limitation also was carried over into Section 2.
Yes, sir.
And is the agreement to change that to 4 years also?
Yes, sir. That is correct. Okay. Yeah, on line 26, Chairman Lane.
Discussion.
Line 26.
Yes.
Yes, sir.
Yes,
That's correct.
There's one other thing I forgot about here. We got in here in several places we've got cut and carried away, and I think the agreement in subcommittee that would be changed to and/or, because there's a possibility they could go in there and cut the trees down and leave them.
Okay.
That's the one we're working from. It says cut and carried away.
Okay.
Yeah. It's on line 65.
Well, I would think, would you not accomplish the same thing just by saying trees are cut?
Yeah.
That's when the damage occurs, when you cut the trees. Yeah. Yes, ma'am. Ms.
I'm sorry.
What you got? I know.
Jenna talked to me about this, and specifically in the case law and why this language is used.
Okay.
It's just a term of art.
It's a term of
That's why
art,
we
yeah.
had it cut, in case someone, if you cruise 3 acres accidentally and left it, you could argue that I'm not guilty of cut and carried away because I didn't carry it away.
And it's actually on line 51.
Well, you got a trespass, though. Have you not got a trespass?
You would still have
Damages, trespass. Okay. Let's get back. Let's one person at a time talk, please, Mr. Weldon. You have over here, I believe, who is it, Ms. Evans?
Yes, sir, Mr. Chairman. Thank you. I just wanted to say that the cutting and carrying away issue is also on line 25, I believe.
And what we're saying is that is a term of art. The question is from having, what's our lady's name?
Jenna Dolbay. She served as your...
I know, Jenna did. And she has urged that language because of it being used in case law that's been studied. And we talked just now about the fact that if they cut it and left it, they still have accomplished a trespass and done damage to property. And you, Mr. Crawford?
Mr. Chairman, I've just gotten confused as to carrying away talking about the trees or the people with the saws.
Beats me. Okay. Did y'all have anything as far as questions of the presenters? If not, we have some others who I believe want to address this bill. I see Mr. Steve McWilliams with the Georgia Forestry Association. Let me get y'all to step aside and let Mr. McWilliams address us.
Thank you, Mr. Chairman, members of the committee. My name is Steve McWilliams, and I'm president of the Georgia Forestry Association, and my comments will be very brief, and that is mostly to thank Chairman Lane and his subcommittee and certain individuals on the subcommittee, particularly Representative McKillop, who have, in our view, brought to us a far, far better piece of legislation than we began with. And we would simply like to echo the request that the statute of limitations be changed from 6 to 4 years. That to us would make it an even better piece of legislation. So we thank you for your patience. I think this is about the 5th time that this bill has been before either the full committee or a study committee or a subcommittee, and so I think a lot of progress has been made, and we appreciate all the work that's gone into it.
We have tried to dutifully address this long festering issue.
As is your custom, Mr. Chairman.
Thank you. Thank you for coming and being with us, Mr. Williams. Is there anyone else who would like to address the committee who has not signed up? If not, we'll close off any further public comments. The bill is now in the rest of the committee. First, is the chair will entertain a motion. We have a move to pass, seconded. Thank you. And do we have any discussions on the motion, first of all? Do we have any proposed amendments? There were some people speaking of amendments. I'm not going to wait forever. If you got an amendment, let's bring it up.
I'd like to make it a 6-year statute of limitations on line 26.
All right, so on line 24, change the 6 to 4. Actually, what we can, and we're going to strike line 26, excuse me, yep. Well, let's take that first. The amendment is to change 6-year statute to 4 years on line 26. Any further discussion on the amendment? If not, Chair will call the question. Amendment 1, McKillop. All in favor signify by saying aye. Aye. Opposed, like sign. 1 no. Mr. McKillop, do you have another amendment?
On line 18, change 6 to 4.
No, what we're going to do is strike entire section 1. If you want to. The motion is to strike the entire section 1 and renumber the sections. Do we have a second? Second. It's been moved and seconded. Do we have discussion on the motion? There being none, the chair calls for the McKillop amendment number 2. All in favor signify by saying aye. Aye. Opposed, like sign. Motion carries. Do you have any further amendments, Mr. McKillop?
No, sir.
Ms. Stevenson?
I was going to move an amendment.
All right, same ones?
Yes.
Chair has one amendment he will make, which is the line 41 under section 4, and that will be adding in the term invisibly. I will read what we have. Has clearly, comma, strike the and, accurately and visibly mark the boundary. I'll make that in the form of a motion, and it's been seconded. In discussion on that motion, you have a yes, sir.
I just have a quick question, Mr. Chairman. In light of that, the motion also includes striking remaining language in the section, because that's when it gets into the stuff about how it's to be marked. Is it the chair's intention that that language would be removed as part of the amendment?
Well, I'm sorry, I didn't follow your suggestion. Go back for me, please.
All right.
Tell me where you are.
Extending on in the language, beginning at the middle of line 42, it begins a discussion about the markers and etc.
Mm-hmm.
Is it the intention of the amendment that all of that language would be removed and simply rely on the language of clearly, accurately, and visibly mark the boundary?
Let's see your point. Let's see. Probably will be right. I don't think we need to have that further provision about it, because your directive as to the limiting of liability of the owner is the fact that the owner has clearly, accurately, and visibly marked the boundary. Now, how he does that for the purpose of the cruising is up to him. You want to make your motion?
Well, I was just asking to clarify the chair's motion as to what the proposed amendment is.
Well, I had not moved to strike that. We do have that first part. You wanted me to go ahead and read as a second part, and then strike the sentence that begins on line 42 as used down through the rest of the section. I'm looking at the looking at all of it. Yep. I'll amend my motion. The motion will be, as first stated, clearly, comma, accurately, and visibly marked, etc. And then beginning on line 42, the sentence beginning as used in this code section, strike from that point down through the end of the section 4. Make that in the form of motion. Been motion made and seconded. Any further discussion on the motion? If not, chair will call the question. All in favor signify by saying aye. Aye. Opposed, like sign. Motion carries. And Ms. Dobbs, do you have a?
I had a question about your amendment, Mr. Chairman.
But you want to go ahead and ask it? We can still.
Well, my question was, is just leaving it with the
Pull your mic down so we can hear you, please.
just having the language just provide clearly, accurately, and visibly without a definition like we had here originally. Would that not possibly lead to more litigation with arguing what is clearly, accurately, and visibly?
Well, I think that would be a factual issue that regardless, I mean, it's going to be by accurately, it's going to be the line itself that divides the property clearly would be whatever means they have to stake it out, but the visibly is the main thing I'm looking for, visibly being one that's something you can see as a factual matter. Okay. And how they do that, most times they do it by painting the trees, tying ribbons on trees. I've heard of even using, lime as a part of it, but that's up to the property owner. Over here we have Ms. Evans.
Thank you, Mr. Chairman. Just to make everything uniform with our changes to say cut or cut and carry away on line 25, I would propose an amendment to insert after the word on line 25 after the word cutting to add the words or cutting to that line, and then over on line 26 to strike the on line 26 to strike the word removal and insert cutting or cutting and carrying away.
Let's read what we got here. Provided, however, the actions involving the unauthorized cutting or carrying away. So you have two different things that could constitute that part of the trespass.
But to put or cutting, it would read, provided, however, that the actions involving the unauthorized cutting or cutting and carrying away, so that we keep that term of art like we've done in the rest of the rest of the bill. On line 65.
I'm gonna go to Ms. Travis on this. Ms. Travis, problem.
No, I followed it.
All right, state your amendment for me one more time, then we'll see if we get a second.
Sure. On line 25, after the word cutting, insert the words or cutting, and on line 26, strike the word removal and insert the words cutting or cutting and carrying away.
All right, what we do after you have your first cutting, a comma there. Unauthorized cutting. Huh? What's your confusion, ma'am?
I thought it was you were saying that actions involving the unauthorized cutting or cutting
and carrying away.
That's what it would read after all you have to do is add the words or cutting between cutting and. It's confusing because there's two.
And I think wouldn't proper punctuation call for a comma after the first cutting? No? All right. Second. So moved and seconded to the Evans amendment. Any discussion on the amendment? Want to raise your hand? All right.
There is a second part to her amendment.
Put your mic around so we can hear you, please.
Sorry, there is a second part to her amendment. I just make sure.
Yes.
I agree with the amendment and the removal also portion.
Right.
Can I have that read one more time?
Sure. In addition to the changes on line 25, on line 26, striking the word removal and adding the words cutting or cutting and carrying away.
Thank you.
All right. Got it covered? Any further discussion on the amendment? Chair will call for the amendment. All in favor signify by saying aye. Aye. Opposed, like sign. Motion carries. Any further amendments? No. Yes, ma'am.
On line 77 and 78, now you've deleted the definition, so you're going to need to make a fix there. So you want to say clearly, accurately.
Yeah. I like that. Yeah, let's do that. So we'll say when boundary lines are clearly, comma, accurately, and visibly marked. And we can strike out as such term is defined in code section 51-3-3. So take out that entire phrase then it just reads, the way it will read is, when boundary lines, starting on 77, when boundary lines are clearly, accurately, and visibly marked, the court shall presume the defendant was a willful trespasser. All clear on that? I'll have that in the form of a motion to amend. Moved and seconded. Any discussion on the motion? Everyone understand it? All in favor signify by saying aye. Aye. Opposed, like sign. Motion carries. Any further amendments? Now we'll call on the main question. The motion is to adopt, pass House Bill 135 as a committee substitute as amended. All in favor signify by saying aye. Aye. Opposed, like sign. Motion carries. Thank you, Representative Black. Appreciate you bringing this nice piece of legislation to us. We are back to the previous Mitchell House Bill 419. Do you have your proposed amendment prepared? And
yes, sir.
Where is that? Has it been distributed?
Yes, sir.
I want you to go ahead and, yeah. The chair will bring back House Bill 419. I know I got it somewhere. I got to put it up here. All right. As I recall where we were before suspending discussion, there had been already one amendment, which is on the second page, at lines. We took out F and renumbered G and H to F and G, correct? And so now we're back to further amendments. And Ms. Oliver, did you have an amendment?
Yes, sir. Very simply, it is my intent by offering this amendment to change the number of days that a homeowner is entitled to notice of intent to foreclose to 45 days instead of the current 30 days set forth in law. And in order to do that, I offer an amendment that creates a new section, I believe would be section 1, to 44-14-162. .2 that only changes the number 30 to 45, and the remainder of the bottom part of the page that has been distributed to you has been blocked out.
All right. That's the form of motion. Is there a second? Been seconded. Do we have discussion on the motion? I think this was something we changed just as recently last year, didn't we?
Yes, sir. In our earlier discussion, we may have stepped out of the room.
Right.
We talked about where the bill that passed last year and all its variations, and Mr. Mitchell and I both believe that we left this committee last year at 45 days as the notice.
My recollection is a little different on that, but every member recall their own. I know it was something took a great deal of debate from last year. Do we have any further discussion on the proposed amendment? Not, the chair will call for the question. All in favor signify by saying aye. Aye. Opposed, like sign. No. Chair is in doubt. We'll have a show of hands. All in favor of the amendment, raise your right hand. 1, 2, 3, 4, 5, 6. All opposed, like sign. 1, 2, 3, 4, 5, 6, 7, 8. The proposed amendment fails for number. Excuse me. Any further amendments? We're back to the main bill, which is House Bill 419 substitute, which is LC 294750S, as amended. All in favor of the bill passage signify by saying aye. Opposed, like sign. Okay, we'll have another show of hands. All in favor signify by raising your right hand. 1, 2, 3, 4, 5. All those opposed, like sign. 1, 2, 3, 4, 5, 6, 7, 8. Motion fails. The bill does not pass out with recommendation. What's our next bill? I lost track where we were from the time is Mr. Kidd, has he come yet? You would do that for him? All right. Sure. We've had Cooper. We've had Black. Mr. McKillop, we still got your bill too, do we not? I'm going to go ahead and take Mr. McKillop because I told him once we got everybody who's here out of the way, we would do that. And Mr. Powell, what about Mr. Powell? Is he House Bill 455? That's been done? All right. Mr. McKillop, we're going to bring before the committee House Bill 102. Would you
like to represent it from here, Mr. Chairman?
Yes, sir. Let me get your mic on. I'm sorry. Go ahead, please.
Bring before the committee House Bill 102. This was something that was brought to me by folks in the environmental community based specifically on conservation easement property land, and it's something that has occurred in other states, and again, just sort of preemptory so it doesn't happen in Georgia. It provides a statute of limitation for people to bring an adverse possession action regarding prescriptive title to any property that has been deposited into a conservation easement or made subject to a conservation easement. It requires that they bring it within 4 years if it is already ripe at the time that it's filed.
Yeah, okay. I'm sorry.
So it provides that they bring it within 4 years if the action is already ripe at the time that it is filed. There is a carve-out for utilities because it would have otherwise been overly burdensome on utilities to go through and catalog all their properties. So we were approached by the utilities and did a carve-out for them so that they can still, on the rare occasions that they do use those adverse possession actions, have that ability. And the point of it is that land that's put into a conservation easement is rarely, if ever, visited. And the point of it is to just let it be and let it sit. It prevents somebody from setting up a road across conservation easement property that after 21 years they would have the legal right to use and sue for adverse possession of it. So it puts an end to that. Happy to answer any questions.
We've seen this bill already. Yes.
Yeah. In fact, it's got an amendment that you suggested.
Well, and that's probably about the only reason I remember it, Frank. But is it exactly the same? Other than that, I don't recall the utility carve out being in it before.
No, that's new. We carved out. They approached me after we made the amendment. Your amendment was to make sure that anybody who has it now gets through 2015.
Right.
And
that they would never have less than 4 years.
They would never have less than 4 years. So we added that amendment in, and then we added the carve out for EMCs, municipalities that run electrical service, and anyone subject to PSC control. A lot of times an EMC may have a string of poles across someone's field that they got permission from somebody once upon a time, but then didn't, and somewhere down the road they have to say, look, we have to try and gain title to that or that easement, that use by adverse possession, and so they wanted to carve out, and I understood their point in that, given their unique situation in real estate.
Anything further, Mr. Crawford?
So we're not contemplating that they would attempt to acquire title by prescription, just perhaps an easement by prescription where they might have a line run.
Well, it could be title to an easement, could be title to not full fee simple title, but generally it would be.
Well, that's my point, being that I'm struggling to envision a circumstance where they might have a desire to try to obtain fee simple title by prescription.
And they may not. They may just seek to obtain title to an easement.
Would you be receptive to limiting, since they're going to be carved out, to limiting their ability to seeking an easement by prescription? I'm just a little concerned if we have a rule that should apply to anybody else, but let them come in way on down the road and try to actually take somebody's property as opposed to an easement.
Given the right language, I don't have any objection to that. I don't think that these folks are out there trying to take fee simple title. I think they just want easements. So I don't, you give me the language, I don't have any problem with the idea of it.
How about if we insert it on line 23 after civil action, something like an easement or other right of access by prescription, something to that effect, by an electric membership, blah, blah, blah.
Could you sort of flesh out the blah, blah, blah part?
Yeah.
Well, the blah, blah, blah part's already on the page.
Okay, all right.
Yes, it is.
All right. Why don't y'all work on that for the wording for the moment. And I think you've got a question, Mr. Weldon.
Thank you, Mr. Chairman. To the author, is this coming out of a certain set of facts? I just don't have a feel for the factual context.
It's preemptory based on things like we have the Athens Land Trust in Athens. This has happened in other parts of the country, not in Georgia. This is preemptory. It says basically if you think you have a cause of action for title by prescription, or any kind of title, an easement, whatever, by prescription over someone else's land because you've used it for 21 years, if that land is deposited into a land trust, you need to go ahead and bring that action within. If it's ripe already, you need to go ahead and bring that action. So it's happened in other parts of the country where, you deposit 1,000 acres, somebody starts driving over it, and after 21 years in Georgia, you would have the right to drive over it. You would have an easement by prescription.
Okay, so this is just going to put they're going to have a drop dead date, July 1st, 2015.
Or 4 years
or
after.
4 years after the right arises.
Correct.
So if let's say somebody, like I started driving over somebody's property that was deposited in a land trust, the 4 years passes and I don't exercise it, then my property is sold, and without that access, my property's landlocked. And how would that?
The only way you have a right to access the property, if you've been using someone else's property openly, obviously, notoriously, and without their permission for 21 years. If you have been doing that, then all this says is if that land, if the acre between is deposited into a conservation easement, you have to bring your action for your right to use that driveway within 4 years of that land being deposited in the conservation easement.
Okay.
So you still have the right to do it. You just have 4 years to get it done.
Okay.
And if you don't, you lost it. It's a statute of limitations.
And if I own that property and I left it to my children, and I didn't execute that, and I still use the roadway, and would my children would then have the right, subject to 4 year statute of limitations?
4 years from the date the conservation easement is filed. So no one else has the right ever. There's no more tacking. It has to be ripe at the time the conservation easement is filed. And so you get 4 years from that date to bring your action for adverse possession if you have it.
So then that would make my property, if that was the only way I could get there, was over that road, that'd make my property essentially not marketable.
If it's the only way you have to get there, you have a right of action for private condemnation of a right-of-way. And you can go to court and say, I need to access my property. It's against the public policy of this state. And they will carve you a piece and make you pay some money. There's another legislatively creative way to do what you're talking about doing.
Anything further? I think you have a point down, Mr. Welch.
Thank you, Mr. Chairman. Representative, how is the holder of the easement to know that the burdened property has now become part of the uniform, has become a conservation easement, been placed into a trust of some sort?
He's deemed to know constructively because it's filed.
Okay, even though that's not his property.
Correct. Everyone is deemed to know constructively because it's filed of record.
All right. Anything further of the presenter? If not, do we have anyone in the audience who'd like to address the committee on House Bill 102? If not, we'll close off further public comments. The bill is now on the breast of the committee. Do we have a motion? It's been moved to pass. Is there a second? Second. There's a second. Do we have discussion on the motion first? No further discussion on the motion. Do we have any amendments? Mr. Crawford.
Mr. Chairman, I'd offer an amendment on line 23 after the phrase civil action to insert the words for the purpose of acquiring an easement or private way by prescription. Oh, repeat. Okay. On line 23, after the phrase civil action, insert the words for the purpose of acquiring an easement or private way by prescription.
And why don't you explain what the amendment will do?
The idea is just to take away the ability of since we're giving them we're excusing them from the new 4-year limit, that at least they couldn't come back and try to acquire fee simple title. I think that the discussion, as I understood it, was that they might need to come back later and try to acquire an easement because they might have a line run or something like that, but not have a written recorded easement. And so this would not interfere with their ability to do that at some later time beyond the 4 years, but they would be prohibited from trying to acquire title, fee simple title by prescription beyond the 4 years.
All right. Understood. Any discussion on the amendment? There was a second to or was there a second to the amendment? We hear a second. All right. There's been a second. Any discussion on the Crawford amendment? All in favor of the amendment signify by saying aye. Aye. Opposed, like sign. Motion carries. Do we have any further amendments? If not, we'll call on the main question, which is a due pass motion on House Bill 102 as a committee substitute and as amended. All in favor signify by saying aye. Aye. Opposed, like sign. No. Chair rules the ayes have it. Now we have Mr. Powell's bill, I believe, and you'll be presenting that.
Representative Kidd.
I'm sorry, Kidd, not Powell, which is House Bill 245.
Thank you, Mr. Chairman, members of the committee. Representative Kidd was not able to be here. He's having some surgery or something done to his neck, so I told him I'd present his bill for him and ask that you pass it out. It's a simple little bill. Glad someone's still awake over there. Basically what happened, what brought this bill about, Representative Kidd explained to our subcommittee that he had co-signed a note with his with somebody, and they had defaulted on the note, and he didn't know about it, and he went to get some credit, and it showed up on his credit report as being in default. He was a co-signer on the note, so and he talked to some other people who'd had that same thing happen. So he brought this bill to require that a surety or a co-signer on a loan obligation would be notified of a default at the same time as the maker of the note, so that they would have a chance to protect themselves from that showing up on their credit report. And we put in there that it to be sent to the last known address provided by the co-signer or the surety, and that the failure to comply with this code section would not affect the obligation created by the loan agreement. We simplified it down to the very essence of what he was trying to accomplish with it, and that's the purpose of his bill, is to just assure that a co-signer or a surety gets notice if the note's in default that they co-signed on.
Very well. Any questions of the presenter, Mr. Nix?
What are the requirements now? Are there no requirements now?
There are no requirements that they have to notify them.
No
statutory requirement. Most of them do. I think we have some of the banking people that testified. Almost all the banks do, and the community banks, they know who's co-signed, who hasn't co-signed, the notice is given. Sometimes it's a large out-of-state bank or some other procedure that they get caught up in that they won't get notification.
The reason I asked that question, I made some of those loans, and I was always after the cosigner. He usually knew before the signer did that he was in default.
And that was the evidence that we had. You know, you want to collect the note, so you're going to notify the cosigner as soon as you can to let them know that they're in jeopardy. So,
I guess I'm just questioning: is this really necessary?
Well, I think that the subcommittee decided that it was something that has happened and can happen and should just be clarified, maybe.
Okay, thank you.
Thank you, sir. And Mr. Weldon?
If I could pose a question to the chairman of reapportionment.
Where is he? We can't joke about that, you know.
This bill, if it's signed into law, this will require even not only banks but individuals who make loans and they have a cosigner or guarantor on the loan to an individual to provide that cosigner with notice, right?
That's right.
Okay. Thanks, sir.
It's a very good bill.
It comes down to being directive in its purpose and application. I think the way you'd apply it. Any further questions of the presenter? Do we have anyone who would like to address the committee on House Bill 245? No one signed up. Bankers sit quietly. So glad to have you with us. All huddled together over there, I noticed too. Do no harm, as the saying goes. Okay. No further discussion. The bill is now in the breast of the committee. Do we have a motion? It's been moved, do pass, and seconded. And we have discussion on the motion. Mr. McKillop.
Yeah, I'd just like to point out a couple things for the committee on this. Number one, and I handed out in the subcommittee, the provision to provide notice is already waived in every security deed that gets signed in Georgia since '95. So unless this, I think this bill is flawed. Unless, with all due respect to my chairman on reapportionment, unless this bill is amended to make it against the public policy of the state to be able to waive this, like we had in the earlier bill, that language. And I think that every note that is signed under that normal security deed, this requirement is already waived because you waive notice, demand, and presentment. And so I think that this is. I like the idea of it, and I wish every bank, and I know most banks do, and things like that, but I think that there's no point in this statute because everybody who's ever signed one of these has already waived this requirement, and it doesn't have any provision that you don't have to waive it. That's my comment.
Nice comments. Do we have any further discussion about the proposed bill? And you have Ms. Dobbs.
With regard to Representative McKillop's suggestion or his statement, is it possible that we can, in essence, have a provision that you cannot waive it in order to accomplish the
that would only be applicable to any loans in the future. You could not change a contractual obligation that currently exists.
Well, would we not consider doing it for the future? If that's the intent of the bill and we think it's a good idea.
If you want to move the table it and work on that, we can do so.
All right, so move.
Been moved the table, which takes precedent. There's no discussion on a motion to table. All in favor of the motion to table signify by saying aye.
Aye.
Opposed, like sign. No. Chair's in doubt. The chair will ask for a show of hands. All in favor of the motion to table, raise your right hand. We got 1, 2, 3, 4, 5. All opposed to the table, raise your right hand. 1, 2, 3, 4, 5. The chair will so rule. I'm gonna rule the table. Work on that. And it is perplexing. We've got one other thing before you leave, if I may, Ms. Dobbs. You're going to be hopefully staying with us. We've got all the bills covered. We've got one item that has come up, and I will only do this by consent of the entire committee. There's a bill which is, what is your bill? Here it is. 525. Which is House Bill 525. This has raised a question dealing with a bill we passed last year and it has to do with the out-of-state, the uniform laws dealing with out-of-state collections of alimony, child support, etc. Is that right?
Long arm domestic relations, long arm statute.
Long arm statute, right. Let me first ask the committee, is there any objection to our consideration at this time of House Bill 525 from Mr. Hatfield? If there's no objection, we'll go ahead and give consideration. You address the bill.
Thank you, Mr. Chairman. Am I on? Okay. Thank you for members of the committee for allowing me to present this bill this afternoon. This is a repair bill, basically, for something that we did last year. And I was doing some research on a divorce case where I had an out-of-state defendant this summer. And I looked at the domestic relations long-arm statute, and we made some changes under a Senate bill last year. And the purpose of the Senate bill was to give Georgia long-arm jurisdiction as to contempt and modification actions. The problem, and that was accomplished by adding the subsection 6 that's now, you'll see at line 21, beginning at line 21. The problem was that we also, for some reason, we amended subsection 5 and included the language that you see that is stricken, lines 15 through 19. The effect of this is that we have caused a contraction of personal jurisdiction as to actions for divorce, because we have added a requirement on there that this arise from alimony, child support, apportionment of debt, or real or personal property orders or agreements. That is so it excludes an original action for divorce now. Additionally, the language that where you see notwithstanding the subsequent departure of one of the original parties from this state, that is really that's unnecessary to have in there, because OCGA 9-10-90, which defines non-resident, specifically defines a non-resident as someone who is a non-resident at the time the actions commenced or subsequently becomes a non-resident. So that's included within the definition. Well, when I found this, I got in touch with Representative Lindsay, and he you're all familiar with his wife Elizabeth, who does a good bit of domestic relations work, I understand, and she kind of ran it up the flagpole of some domestic relations lawyers, and agreed that we probably needed to work on that language. Additionally, if you'll look at the way that the actual bill was drafted, and this was something that we should have caught, and I don't know how it made through two judiciary committees and we didn't catch this, but we put a period. You'll see at the end of subparagraph 5, which is shown at line 20, and then subparagraph 6 is just an incomplete sentence. And so I've talked with Ms. Travis about this, and we've come up with this new draft to try to fix this problem, because as it stands right now, we've got a statute that really doesn't make sense, and it also, I believe, restricts our personal jurisdiction as to non-residents in original divorce actions.
All right, thank you. Is there any questions of members to the presenter? Ms. Is that yours, Ms. Oliver?
Yes, sir.
Thank you.
I followed about half of what you said, but I'm trying to remember. This was the state bar's bill last year that was based on the uniform statute in relation to long-arm statute that was brought forth by the family law section. Am I right or wrong about that?
I'm not sure. It was carried. It was in the Senate. It was a Senate bill, and it was sponsored by Senator Cowsert. No, by Senator Cowsert was the lead sponsor. Now, Seth Hart was one of the signers on it, but it was Cowsert's bill, and but the purpose of the bill, from everything that I've gone back and reviewed, was to address contempt and modification actions.
What am I right though that it was a state bar family law section part of their package?
I really don't know.
As a model long arm statute. That's what my memory is, and I'm just trying to remember if I'm correct about that, because
you may be.
And if I am correct about that, I'd like to know what they think. It sounds like you're right,
Well,
but
I think what they think would be a committee decision, but I think what they want to do, we were attempting to do, and what I think we're finding out, and maybe Ms. Travis can shed some more light on it, we have more narrowly drawn the application of this long-arm statute's intent by this language that's inserted here. They probably came to us saying we want to do something in this area of the law. The matter is taken to Legislative Council, who then puts that idea into the form of a bill. So then from there, it starts the process. I think my problem has been I'm reading, as in this case, 4, 5, and 6. I'm not reading the whole provision,
Right.
And that's kind of leaving out what is it we're doing here.
Well, this is the long arm statute is, of course, it's not just limited to domestic relations. It covers other items, and it might be helpful to.
The first part of knowing these are the things by which it is being applied.
Correct. It says that a court of this state would have jurisdiction over a non-resident if he or an agent in person or through an agent does one of these following things, and then we have the list. The list of these. I will read it real quick, Mr. Chairman. A court of this state may exercise personal jurisdiction over any non-resident or his executor or administrator as to a cause of action arising from any of the acts, omissions, ownership, use, or possession enumerated in this code section, in the same manner as if he were a resident of the state, if in person or through an agent he, and 1, transacts any business within the state, 2, commits a tortious act or omission, etc.
Personal property, orders, or agreement. If one party to the marital relationship continues to reside in the state, my question goes to this now, are we taking that language out, broadening the statute beyond what is the constitutional ability of the long-arm statute?
Representative Hatfield and I talked about this, and I have to say one of the things that troubles me about the bill that passed last year, which was Senate Bill 491, was I drafted it, and I have to say I look at it now and it doesn't make sense to me, because the definition of non-resident is in 9-10-90, and it is if this code section is written in a vacuum, not thinking of the definition of non-resident. So the fact that somebody departs the state, it's already a given by virtue of the fact that they're a non-resident. And I know one of the purposes of the 491 last year was it had to do with process servers. And at first I thought it was maybe your bill got married, but it wasn't quite that. And another issue. Was it tacked on to? I don't think it was, because it was the original bill that. This is a rarity. Senate Bill 491 got introduced and passed, both chambers, no changes. There's not many times that happens. So what you did in 491 last year is you revised paragraph 5 and you revised paragraph 6. Excuse me, you added completely paragraph 6.
Yeah.
Part of the basis for that was you took out child custody and alimony and child support, the money parts, and you put that in paragraph 6. So you talked about modification and contempt, and that was a necessity, and that was needed to extend the long-arm jurisdiction for those purposes. With respect to lines 11 and 12, that language was cleaned up a little bit, but that notwithstanding, I clearly don't see how a divorce action is now added, and that was what Representative Hatfield's issue was.
Yeah. Not really, but my point is we got a provision that defines what brings about the right to do a long arm statute action, which is 90, correct? No. 9, 10, 90 defines. Or, well, that's what I'm trying to get to. Defines what is a non-resident. If we did what was in here, leaving it like it is, I'm concerned to say you don't have to have anybody living in Georgia at any point in time to have had carry an action here on these bases.
Mr. Chairman,
because it says, notwithstanding that it come down. Where's the part I'm looking at? If one party or the marital relationship continues to reside in this state.
Well, Mr. Chairman, if you look at that last sentence, this paragraph shall not change the residency requirement for filing an action for divorce. A plaintiff must be a resident for
you got that in there. Okay.
Prior to filing on 1 year. And if you look at specifically addresses the requiring as the modification that the moving party reside in the state. And I do see what you're asking. Basically, have we done anything to expand it beyond constitutional limitations on long arm? Right. But my interpretation of what we're doing here is basically just restoring it to what it has been in the past, and of course it's still also subject to constitutional minimum contacts standard of international shoe and all that.
Anyone else have any further questions, Ms. Oliver? You all right? You have this. Well, thank you.
I'm sorry. Thank you, Mr. Chairman, Representative Hatfield. So, am I understanding correctly that the lines 16, essentially 16 through 18, are delving into issues that are not germane to that particular paragraph 5, but actually are taken up in 6 and should have been struck? That should have been struck last year when this bill was done.
Well, no, actually, we added that language last year in 15 through 19. But the problem is, if as you read it, it's got that clause, and as to all obligations arising from alimony, child support, apportionment of debt, or real or personal property orders or agreements. The problem is with an original action for divorce, you don't have an order or agreement, and so that. I read that as being a general limitation on the whole paragraph. And if that's the case, then we have just lost the ability to get jurisdiction over a non-resident in an original divorce action.
And the subsequent paragraph deals with after you have your order in place.
Correct.
And
the personal property order or the orders or agreements is really relevant to the issue of modification or contempt, really contempt. Because you can't have a contempt unless you got a court order. Right. You can't even an agreement itself is not actionable other than just to sue for breach.
All right. Well, we pass it out. We'll let you go to the Senate and
fight with
them. Tell them they did something wrong.
That's what I'm worried about.
Any further discussion among the members of the committee? If not, the chair will entertain a motion.
Move do pass, Mr. Chairman. If I may, I'm going to request that you or Mr. Hatfield, one of you, check with the family law section chair, and if this needs to be, I'm going to just trust that this needs to be fixed.
Well, I think, and I may be wrong about this, but my understanding was that Elizabeth Lindsay had talked with other members of the family law section. Now I'll try to confirm that before we go further with it on the floor.
I'm not sure if she's in the family law bar committee or not, but we'll find out. We'll get some further clarification from those parties too.
I don't think there's anything wrong with getting some eyes on this, and I agree with you.
All right, we've had a motion, second, and any further discussion? Not any amendments. There be no amendments. The chair will call the main question, which is do pass House Bill 525. All in favor signify by saying aye. Opposed, like sign. Motion carries. That I believe concludes our business for the day. Here's that. Here it is. Yeah, put that back in there for me. Thank you. Yeah, we'll get them back.